Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's program is called Can They Really Say That? French Antitrust Law and Product Denigration. Today's program, we have a very special treat. We have the leader of the French Competition Authority, and she's going to talk about a very interesting set of enforcement priorities that they're carrying out that raises the question, when can denigrating your competitor's product be considered an antitrust violation under French competition law? My co-host today is Matthew Hall. Hi, Matthew.
Hi, John. It's good to be back.
Matthew, what are we doing today?
Well, as you said, John, we're going to be discussing the extent to which denigration of a competitor's product or product denigration can be considered a competition law infringement, focusing on the French competition regulators' recent enforcement activity in the pharmaceutical sector.
Great. Why is that important?
Well, pharma and healthcare generally continues to be a very important sector for enforcement by competition regulators in the EU. And the French Competition Authority, or FCA, has been at the cutting edge of taking on these product denigration cases, which are still relatively unusual, but they're also very interesting, and they show as well the potentially very wide scope of competition law control.
Yeah, healthcare and pharmaceuticals are a huge issue in the U.S. as well, and many times what we see in Europe can influence what goes on in the U.S. So I think this could be very interesting for our U.S. listeners as well. Who is our guest?
I think so, John. I agree. Well, as you mentioned, we are very honored to have Isabelle de Silva, the president of the French Competition Authority, or FCA. President de Silva has been in that role since October 2016. The FCA is the competition regulator for France, of course, and responsible, therefore, for enforcing French and EU competition law within France. And via the European Competition Network, or the ECN, the FCA, of course, cooperates with the European Commission in Brussels and the other EU national competition regulators in enforcing competition law within the EU. Welcome, President de Silva.
Hello, I'm pleased to be with you today.
We also have an old friend of the Our Curious Amalgam podcast, Bill Batchelor. He appeared as a guest in episode number 35, which was called What is the Competitive Drug Price? Understanding Drug Pricing and Competition in Europe. Bill's a partner at Skadden Arps, the law firm, and he's an EU and UK competition lawyer with wide experience in all aspects of the field. And it's also important to know that he is a vice chair of one of the other ABA Antitrust Law Section committees, the Healthcare and Pharmaceuticals Committee. Hello again, Bill.
Hi, Matthew. Thanks for having me back.
Great. So let's kick off. Madame de Silva, thank you again very much for agreeing to come on the Our Curious Amalgam podcast. I think it's going to be a great discussion. We should make our normal housekeeping point, so you and Bill don't have to. But of course, what we're going to discuss here is purely your own personal view and does not necessarily represent the views of any organization. I think the same goes for Bill and his clients. President de Silva, just for our non-EU audience, could you please introduce the FCA and what it's been doing in particular in the pharma and healthcare sector? And just tell us how much of your enforcement at the moment is actually healthcare related.
Yes, of course. So the French Competition Authority is an independent agency in charge of regulating competition in France. We are roughly 200. Our budget is roughly 20 million euros per year. We have 4 core missions. The first 2 are rather traditional. It's combating cartels and abuses. The second, reviewing mergers and acquisition. And the last two, maybe more original compared to American agencies. We issue opinion and we do often sector inquiries. And we also have a specific role in overseeing the regulated legal professions. So we are organized with a board of 17 members, 5 permanent members, including myself. And we have investigation services that are led by a general rapporteur in charge of all the investigation in antitrust cases. And it's true that over the past few years, we have had a strong focus on the pharma and healthcare sector. We have been very active on the antitrust front, also on the merger control. We're going, of course, to comment on the different cases concerning abusive practices. But I might also mention that we have taken some rather original decision in merger between private healthcare bodies. With some of them have been settled with original behavioral remedies so as to ensure sufficient competition between practitioners, for example. And so we also did some rather wide-ranging sector inquiry in the health sector, and the last one was in 2019.
And certainly we can see from your output, Madame de Silva, that your authority is very active in healthcare. It's a state-financed healthcare system in large part. Naturally, that's what happens in healthcare will have been of great interest to hospitals, the Department of Health, the finance department. How closely would you work with the French healthcare authorities when you look at cases?
Well, it's always a major part of the inquiries. For example, when we prepare a sector inquiry in the medicine distribution in France, or the way biological analyses are done, we of course have a lot of discussion with the health authorities, but it is also very important in the antitrust cases we're going to comment on, because many of those cases were really dealing with very intricate process within the public agencies. So we really had to understand in a very detailed manner what was the legal framework and in which way the companies had interacted with the public regulators. So we have an ongoing discussion with the Ministry for Health, of course, but also with specialized regulatory agencies in that field.
I think we'll get onto that when we talk about the recent AMD case. But if you don't mind, let's just set the scene in relation to product denigration. Looked at a high level, of course, in France, as in the EU, we have 2 general basic competition law provisions. The one which is at EU level, the Article 101, which essentially bans anti-competitive agreements, and then Article 102, which bans abuse of a dominant position. And therefore, we need to find, for there to be an infringement, first dominance and then an abuse. And I think it's important to point out that for Article 102, it's often said that the boundaries of what is an abuse are not fixed. And as I said, this really applies, this law is similar in France and at the EU level. Bill, could you just take us through what we've seen at the EU level in terms of product denigration and similar cases, and how those have been, and under what rules those have been looked at?
So at EU level, I think it is fair to say that product denigration cases, particularly in the healthcare sector, have been rare. So we have AstraZeneca, which is probably the great granddaddy of the EU, starting to look at allegedly abusive behaviour in the healthcare sector. Before that, their focus tended to be on things like distribution and parallel trade. But AstraZeneca is the first time you see, if I may say so, a relatively innovative use of the abuse of dominance rules. The first abuse there was objectively misleading an authority. In that case, the Patent Office. AstraZeneca allegedly misleads the Patent Office to secure additional protection for its IP and thereby keeping generic drugs off the market. The second abuse there was the use of a regulatory procedure in a legitimate manner, so it was permitted to use a procedure in this way to deregister its originator product, but with the sole purpose, the court finds, of restricting generic competition, preventing generics getting access to the marketing dossier so as to get onto the market more quickly. And the Commission is upheld on those two abuses by the Court of Justice in C45710, a 2013 judgment. Now, that is abuse of dominance. And of course, you need to find that the pharmaceutical company is in a dominant position before you can apply those rules. In pharma cases, I think it's fair to say authorities have taken a relatively narrow approach to market definition, and so dominance has been shown relatively frequently. 5 years later, the EU court also weighs in on a misleading conduct case, again in the pharmaceutical sector. And here they find that two rivals, Roche and Novartis, agree with each other to allegedly exaggerate the off-label risks of a drug that they both sold in competition with one another. And that's a 101 case, so no need to show dominance. That is found to be an infringement by the Italian authorities, and the Court of Justice agrees, and that's C179 of 2016. I think Madame de Silva will tell us in a moment, but I think it's fair to say that the French authorities have used the concept of denigration much more actively than we've seen at EU level, both under Articles 101 and 102. And we've seen a series of cases such as Plavix, Subutex, Duragesic, and Avastin being taken by the French authority.
Yeah, let's look back at some of those cases, Madame de Silva, please. Well, as I mentioned, we'll get on to the very recent, or the September 2020 AMD case, but could you please set the ground, or lay the ground for us to explain what previous disparagement cases the FCA has looked at, which Bill just briefly mentioned?
Yes, of course. And I agree with your comment that we have seen more French cases, for example, than we see at EU level. One reason for that might be that when you are looking at the health sector or medicines, there are some important differences based on the national legislation. So that might explain why the cases tend to remain at the national level. I would like to say first that the authority has a long-standing practice of prosecuting denigration or disparagement as an abuse of dominant position, and not only in the pharmaceutical sector. For example, we have several examples of abuse cases in the telecom, in the energy, or in the food products sector. So this is something that is rather common in our overall enforcement. The condition for denigration to be considered as an abuse of dominance in our decision-making is that this must be linked to the dominant possession held by the infringing company. And in all the different cases in the pharmaceutical industry, you must have unfounded and biased representations that have had an effect on the dynamics of the market. And in most cases, we find that those biased representations will be reinforced by the reputation and the credibility of the dominant operator on the market. So as you said, we have had several denigration cases since 2013. I will give you a brief overview of the differences of each cases. The first one was the Plavix cases of 2013. It was the first case in which we issued a decision regarding denigration in the pharmaceutical sector. And it was the case concerned practices initiated by Sanofi against generics of its blockbuster medicine Plavix. In that case, just before the entry on the market of several generic versions of Plavix, Sanofi implemented a global communication strategy aimed at raising doubts against the safety of these generic medicines. For example, Sanofi argued that generic versions of Plavix could not use the same element and could not be registered for all of Plavix medical uses. And Sanofi tried to raise many safety concerns, which were untrue. And this, in that case, the communication plan was targeted at doctors as well as pharmacists. So in that first case, we issued a 40 million euros fine for abuse of dominance. And this case was confirmed by the Paris Court of Appeal and by the Judicial Supreme Court. The second case is the Subutex case, which was quite similar because we also had the behavior of a pharmaceutical company aiming at limiting the entry of generic versions of its own products. So it's really a classic case of trying to raise barriers to entry to a competitor. The medicine was Subutex, and in that case, there again, we had a global plan to increase fear among doctors and pharmacists, trying to say that this new generic drug would raise risk for the patients and that if they were to change their medical treatment, there would be a serious issue for their health. So they were really trying to raise fear in all the actors involved. And we also found in that case that those practices were quite effective in limiting and delaying generic entry. So we really saw an impact on the market. So in that second case, the fine was 15 million euros for the dominant company. The third case was rather different. It was a Durogesic case of 2017. We have some common elements with the first two cases because we sanctioned a series of practice by a registered distributor of the Princeps medicine who wanted to block the entry of generics on the market. But the original feature of that case is that we also sanctioned the practices aimed at the French Medicine Agency. So it was the first time in which we found as an element of the abuse the way the company had interacted with the regulatory agency to try to delay the decision that had to be taken by the national agency, because this was a case where the generic had been approved at the European level, and there needed to be a decision by the French agency, but the French agency no longer had really something to evaluate. They only had to say yes to the entry to the market. And in that case, the company really tried to block that process, to delay it by using false claims. So it was a rather original type of conduct that we found because it was directed at a public organization, a public agency, which role is really regulatory. And also in that same case, we had a wide denigration campaign aimed at pharmacists and doctors. And in that case, 25 million euros of fine, and it was recently confirmed by the Paris Court of Appeal last year. And so those were the first three cases before the fourth one we're going to comment a bit later on.
Yeah, thank you. I think that's very interesting. It shows us the wide scope of the scope of competition law. And also I was very interested to hear you comment that that you've used this concept in other sectors. I think you mentioned telecoms, energy, and food. So this is obviously something which other companies and their competitors and customers would also need to be thinking about. Let's move on. I think we should dig in a bit more detail. Bill and Madame de Silva, we looked at, we referred, or Madame de Silva referred to some of the requirements for finding an infringement. I think, Bill, it'd be interesting if you could comment from a practitioner's point of view on how do we draw the line between what might end up being unlawful disparagement and just being able to make an objective comment about a product's qualities. I mean, if you could lead us through a bit of practitioner's point before Madame de Silva could maybe help us with a bit more of her viewpoint on that kind of tricky practice point.
Definitely. Well, I hope that Madame de Silva will, of course, understand that clients are extremely concerned that they stay on the right side of the law. And so when we do compliance trainings at pharmaceutical companies, the French practice as well as the EU principles are very much front of mind. And so you take the business people through the denigration case laws, you try and give them examples of where the line should be drawn. You might imagine an originator are very proud of their medicines. They say, well, we know best how this science was discovered and how it promoted and developed over time. And so you need to calm them down a little, and you say, well, yes, of course, but now exclusive rights are ended, and you need to be very objective about how you describe your drugs in comparison with generic rivals that will soon enter the market. And you're very careful to say, well, everything you must say should be objective, should be in the best interests of patients. And when you do engage in detailing activity in an ethical and appropriate manner with physicians, everything you say must have an objective basis. One of the things that is a little tricky, I think, in some of the French case law, but I'd be very grateful for Madame de Silva's observations, is you see in Plavix and Subutex, I think, an entirely understandable standard. You can't make statements that are without objective justification. That has to be the benchmark for any kind of ethical dealings with regulators or physicians. That happens. One of the difficult things, perhaps, is in fentanyl and duragesic, where you see the Paris Court of Appeal going slightly further than that, but in a way that makes compliance counselling quite difficult. So information likely to discredit a competitor will be disparagement, regardless of whether it's accurate or not, unless the information relates to a subject matter of general interest with a sufficient factual basis and expressed with some measure. So you need to be restrained in how you express yourself. That's quite a difficult practice standard to train companies to, because the company may say, well, we do think that our brand is a successful one for a good reason. We may have information about why we think that ours is one where patients or physicians are reassured by the brand, and they may or may not want to use a generic. And that's something where we should say we can make fair statements about the merits of our originator product versus the generic on the market. So that can be a harder one to address. I don't know whether, Madame de Silva, you have a feeling for how that line can be drawn.
Yes, I think that you have described very well the compliance dilemma and the challenge when you are working within those companies. Of course, they want to promote their products, and they think that their products are the best, otherwise they wouldn't be distributing them. So I think that there are several elements you should take into account. First, are you liable to be considered a dominant company? As you have underlined, it is rather easy to be considered a dominant company in the pharmaceutical industry because the markets tend to be narrowly defined, but it is not always the case. So I would say a first question is, am I dominant in this market for this medicine because I have an 80% market share? And in that case, I should be more cautious. If you have lots of alternative, then maybe you're not so much in the spotlight and maybe you don't have such a high level of conduct to comply with. A second element is the timing, considering the development of the market. When you are at the moment in the market when a generic drug is allowed and can be introduced, then it is a difficult moment and you should be careful not to be considered that you are trying to block the entry of a competitor. So you must know from the different decisions I have mentioned that we don't look kindly at a conduct that would try to unfairly block the arrival of a competitor. And finally, the issue of the message and the way you distribute the message. As you have mentioned, the Court of Appeal went even further than we had gone in the decision in terms of what is an objective message. It is a rather restrictive definition of what you can say. I think that you must be very accurate and you must be careful because in some cases, for example, the IMD case, some elements of the speech could be found to be true, but they were missing other elements that were making them a bit biased, a bit misleading. So it's not only what you say is true, it's how you present it. Are you missing some relevant facts when you are putting forward this scientific element, for example? And who are you talking to? It's not the same if you are having a scientific debate with a researcher doing a study, or if you are talking with a regulatory agency, or with a doctor, or with a pharmacist. So you have to, each time you talk with some of those actors, you might have a different level of what you can say and how you say it. And finally, I would say that in several cases I have mentioned, there was a global plan to block the entry of the medicine. So even without going into the detail of what they said and how they said it, they were having a sort of global approach that I don't want this medicine to enter the market. So even not the discussion was not on which is the best medicine. So I think that those are the elements of caution I would put forward for the compliance department of those companies.
Thank you. That is extremely helpful. And I think a lot of in-house and private practice lawyers will be taking detailed notes from our podcast on those points. So thank you, Madame de Silva, for that. You mentioned a global plan at the end there as one of your points. And of course, bearing in mind that when we're talking about abuse of dominance, the company needs to be dominant. But let's move on from there to the AMD case, which we've mentioned a few times. This is a decision from September 2020 by the FCA. As we've been discussing, your fourth product denigration case in the pharma sector only. Very high fines imposed in that case, totaling 444 million euros on Novartis, Roche, and Genentech. Starting with the basics, this was interestingly prosecuted as a collective abuse of a dominant position. So, Bill, could you just take us through, firstly, before we ask Madame de Silva to look more at that case, what is collective dominance? How does that work?
Well, Matthew, I'm showing my age by saying I do actually remember some collective dominance cases, but of course they tended to be in the 80s and 90s and fairly rare animals. So the idea of collective dominance is that through being a tight oligopoly or through cross-shareholdings or through some other common face to market, you have companies who individually would not be dominant presenting a common strategy to the market in a way that the regulator or court can say, well, yes, individually, you're not dominant because you don't have high market shares individually, but collectively, because you have these joint interests in behaving in the market in a particular way, we're saying that you're collectively dominant. And that could be a relatively tricky point to judge because, of course, once you're collectively dominant, all the rigors of the additional laws applicable to dominant companies start to apply, and you're no longer a nippy individual competitor with plenty of other rivals out there. You're assumed to be in a dominant position where strict rules will be applicable as to your conduct.
As you say, it's pretty difficult to work out, or it can be difficult to work out whether you are collectively dominant. Then suddenly you have this whole range of issues arising out of potentially abusing that collective dominance. So let's go back to Madame de Silva. Firstly, would you please explain to us why you took this as a collective dominance case? I mean, there were clearly a lot of links between the companies. So, and then also move on to taking us through what you see as the key messages from that case, please?
Yes. So collective dominance is a notion that is quite interesting from a legal point of view. It was created by the jurisprudence of the European Commission and the courts, and with cases that deal with mergers at the same time as you have antitrust cases. So it's really something that was created globally, but that may have a very important impact on the firms, because if some companies are considered to be globally dominant, then they can be liable to an abuse under Article 102. So it's very important to know whether you have collective dominance on the market. So in that case, in the DMA case, we found that there were several elements that assembled globally were clearly indicative of a collective dominance. So those elements were the fact that Genentech was the company that created the two drugs that are at play in our case, Avastin and Lucentis. The second element was the fact that Roche and Novartis were distributing in Europe those two drugs and paying fees to Genentech for distributing those drugs in Europe. And the third element was the fact that you had several very clear capital links between those three companies. So one was possessing some of the capital of the other, and the third was also linked with some share of the capital. So this was really a triangle of three companies that have a lot of links. And to give you an example, they had steering committees to define the strategy of those drugs globally as regarded the French market. And finally, of course, the market share was very important, because in that case, the Lucentis drug by Novartis, distributed by Novartis, had a huge market share in the treatment of the ocular disease that was at stake in this case. So maybe moving forward to what is the case about. First, this case deals with medicines that treat one of the most severe ocular disease in France, age-related macular degeneration, AMD or DMLA, if you use the French acronym. It is a very severe case, a very severe illness, and it is also one of the illness that cost the most money to the French system, because the drugs and the Lucentis was a very expensive drug, so costing a lot to the French budget. And what we found in that case, it's rather original, because Lucentis was originally the authorized anti-VEGF medicine used for the treatment of the AMD. And the other drug, Avastin, was really a drug created in the same class, but created originally to treat certain cancers. So at the beginning, there was no idea that this drug could be used to treat ocular disease. So some doctors started to try this drug, because they saw that certain cancer patients were having a better view because of that treatment they were following. And so it became the fact that many doctors started to apply Avastin to treat this disease, but the price of the two drugs were very different, because a Lucentis dose would cost almost 1,200 euros, while at the same time, if you were to use Avastin, it would cost you only 40 euros per dose. So it was 30 times more expensive to use Lucentis, which was the only drug approved for this ocular disease. So I think that the whole case came from this difference in the two drugs and their prices. One was approved for this ocular disease, the other was not, but began to be used very globally by doctors, and not only in France, in other European countries, for example, in Italy, in the UK, and also in the US. And in the US, you had the same difference of price. A Lucentis dose would cost you $2,000, and Avastin would be much cheaper. So what we found was that those three companies really tried to prevent Avastin becoming an alternative for the treatment of this ocular disease, which was very profitable for Novartis, for Genentech, and also for Roche, who had a share in Genentech. So you find once again the relation between those three companies. And they started to implement a strategy to spread false representations about Avastin being dangerous for the patient, and also putting at risk doctors if they were to use this medicine, because they would find themselves in a professional and criminal liability risk. So what we found is that those companies created obstacles to the initiatives that were taken by the French health agency, who wanted to promote the use of Avastin so as to save money in terms of the money that this was costing to the global health system. And for example, some of the ways in which the companies tried to stop the development of the use of Avastin was the refusal to give samples of the drugs so that science study could be conducted, and also a very intense communication campaign towards agencies, government, parliament, so as to delay the initiatives that wanted to make it easier to use Avastin as an alternative to Lucentis. So globally, we found that these practices were successful in terms of reducing the use off-label of Avastin, and also that they had a significant impact in the way the French agencies could negotiate the Lucentis price, because you have the possibility as an agency to discuss the price with the pharmaceutical company, so that this price is fair and for the company and also for the health sector. So so those different behaviors we found to constitute an abuse of dominance.
And it was a very, and I think it's clearly a part of a global plan. If you look at the published material on it, and I think it's a good, very recent example of how companies, dominant companies, need to be very careful in this area. So thank you for that. Thank you very much for that summary.
Yeah, and Madam Silva, this is very, very interesting. Thank you for all the really interesting information you gave us today. I want to shift gears a little bit, if I could, and ask you more of a career question. What advice would you have for young lawyers or young economists who want to get into competition law? What sorts of experiences should they look for?
First, I would really encourage them to join this field, because I think this is one of the most fascinating area of economics and law today. You have lots of opportunities, you get good salaries usually, and it's also a field that seems to be very open to women in terms of opportunity, and very international. So I think I would encourage them to go that way. Maybe I would also encourage them to have maybe a prior experience outside of the field of competition. Competition lawyers tend to be very specialized, which is good, but it's always interesting to have had a different experience, for example, in government or in another area. So maybe I would say you have a few years at the beginning of your career when you can go and try different things. And then, of course, you need to specialize at what point, because competition law is not for everyone.
Great. And a different area of questions. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
I don't know if it's interesting, but I'm very passionate about music, opera, and I did some singing myself when I had the time to practice. So this is something that is very important in my life: music, opera, ballet.
If we were to put a piano on, or maybe give you some accompaniment, would you be in a position to sing today?
I might, but I will not go in that direction. Thank you very much.
It was worth a try. Okay, well, let's go to our final segment that we call The Curious Hat.
And now it's time for The Curious Hat.
When we are together, we actually have a real hat. And in that hat, we put a series of questions, and the guest gets to pull a question out of the hat, and they get to ask that question. Since we're doing this remotely, I have a list of the questions, and they're numbered from 1 to 25. If you could choose a number between 1 and 25, I will ask you that question that corresponds with that number.
Okay, so I will choose 9, please.
Okay, question number 9. If you had to describe yourself in 3 words, what would those 3 words be?
I'm passionate, very dedicated, and I like to have fun.
And how do you balance those three parts of you in your life?
I think that they have a mutual. I think in our jobs it's good to laugh from time to time. Some of our cases are not so funny, but we tried at least to have a good time with my team and to do seriously the job, but without taking ourselves too seriously.
Okay, and then I'm going to ask you the one last follow-up question. Now, we asked you if you could describe yourself in 3 words. If you could describe the perfect podcast in 3 words, what would those 3 words be?
So I think it should be informative, original, and funny.
I was hoping you were going to say Our Curious Amalgam. And with that, thank you so much for being on our program, and we will see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.